Hi guys, and welcome to another episode of Attorney Job Vlogger, Law for the Everyday Layman. Today we'll discuss a topic which is very common, no? The crime of estafa or swindling. Okay? So if you like my videos and you want to see more, please hit the subscribe button. Also, please remember that this is only for educational purposes and is not a substitute for proper legal advice or for studying and understanding the law. Okay? So let's begin, no? In general, estafa is known as swindling, no? And it involves fraud, okay? In general, no? And in general as well, in order to constitute the crime of estafa, the following elements must be present, no? Again, this is in general. First, the accused must have defrauded, niloko, no? Must have defrauded another either with unfaithfulness or abuse of confidence, or second, by means of deceit. And when we say deceit, it includes false pretenses, fraudulent acts, or fraudulent means. Okay? Now, in case of abuse of confidence, deceit is not necessary in that case, no? Because all that is required is that there be confidence reposed and that confidence is abused. Okay? An example is where money or personal property is entrusted to the offender or to the accused. Okay? And the second general element, no, or element in general of the crime of estafa is that damage or prejudice which is capable of pecuniary estimation, meaning the damage can be quantified in terms of money. Okay? The damage or prejudice capable of pecuniary estimation is caused to the offended party or a third person, namely the victim, no? And that damage, no, which is quantifiable in money, will serve as the basis of the penalty for estafa. Okay? Now, let's discuss the first of the two kinds. So, in general, as I said, there are two kinds. Estafa with unfaithfulness or abuse of confidence, or estafa by means of deceit, meaning false pretenses, or fraudulent acts or fraudulent means. Okay? So, when we talk about estafa with abuse of confidence or unfaithfulness, there are also different kinds of there are different means or methods of committing that offense. Okay? But when we say estafa with unfaithfulness, okay, the offender, no, the accused, he has a pre-existing onerous obligation to deliver something of value. Meaning there's already an agreement before that he will deliver something that has value. Okay? And second, he alters its substance, no? Like instead of his obligation to deliver sugar, he substitutes that sugar with salt. Okay? Or he can alter its quantity or quality, in which case there must have been an agreement as to the kind, because if there is none, then the mere delivery of a thing which is not acceptable to the complainant or the victim is not estafa, no? So the remedies in that case, if it's not acceptable, would be a civil action, maybe for a rescission or damages or anything under the civil code. Okay? And finally, there of course must be damage or prejudice. In all the discussion later, no? All throughout the discussion later, there must be damage or prejudice either to the offended party or the victim or to a stranger or third party. Okay? Now, when it comes to estafa with abuse of confidence, no? First, money, goods, or other personal property is received by the offender or the accused in trust or on commission or for administration or any other obligation involving the duty to make delivery, okay, or to return it, no? Okay, such as when an agent receives the money of his principal, okay, like that, no? In such case, the money or the goods must be received. Okay, it should not be taken by the offender because otherwise it may be theft and not estafa. Okay, the receipt of the goods or the money, no, by the offender must give him juridical possession. Okay, take note, juridical possession is different from material or mere physical possession. The offender should receive juridical possession over the thing, meaning that the offender has a right over the thing which he can set up even against the owner. No, an example is where the agent is entrusted with money to pay the bills of the principal. The principal cannot simply ask for the money back right away because the agent has an obligation to perform unless the principal cancels that obligation of the agent to perform. Or a better example, where a truck, no, is subject of a lease. The person who borrowed the truck can set up his right over the truck, no, against the owner of the truck. He can say, don't get it yet because that truck is subject to the lease until the lease expires, no? As long as ownership should not be transferred to the offender, okay? Like for instance, in a simple loan, no, where a person borrows money, ownership is necessarily transferred in that case, no? Because it is a loan for consumption. You're going to use that money, okay? So it does not apply in that case. The obligation in a simple loan is to return the same amount but not the exact bill. Okay? So ownership is transferred in that case. So there is no estafa there. Okay? So second element of estafa with abuse of confidence is that after that person has received goods or money or a personal property, no, there is misappropriation or conversion of such money or property by the offender, okay? Or he denies having received it. In this case, there should be intent to defraud, no? In other words, the offender, the accused, no, he uses or disposes of the thing as if the thing were his own, okay, or for his own benefit. Or he can use it to devote it to a purpose different than that which was agreed upon. For instance, no, instead of the funds of the principal being used to pay the bills of the principal by the agent bought a hot dog. Okay? Or in case of the example of a truck under a lease, the truck was never returned after expiration of the lease, but instead was sold to a third person. Okay? And another example, no, a ring was deposited for safekeeping, but instead it was sold. Okay? So it's in those cases, the thing itself, no, the money or the property was misappropriated or converted to the personal use of the offender. Okay? Third element, such misappropriation or conversion or the denial is to the prejudice or the damage, causes damage to another. Okay? Now, it's not necessary that the offender gains or benefits, no? It is sufficient that the offended party or the victim suffers loss or damage. And finally, there has to be a demand made by the offended party to the offender to return the thing, no? The failure to account for the thing is circumstantial evidence of the misappropriation or conversion done by the offender. Okay? So in other words, demand will not be necessary if there is evidence of actual misappropriation of the goods by the offender. Okay? Now, estafa here is different from theft. Take note. Because in theft, only material possession is taken with the intent to gain by the offender. But in estafa, the offender has juridical possession. He has a right over the thing. Okay? And in case where there is no juridical possession, just material possession, such as in the case of a domestic helper or a teller in a bank, it may be qualified theft and not just simple theft if the taking is done with grave abuse of confidence. Now, if the thing is public funds or public property and it is appropriated or misappropriated or converted by a public officer or a private individual in conspiracy with a public officer, it may be malversation and not estafa. Okay? Now we have estafa by taking undue advantage of a signature in blank. Okay? So here we have a paper, no, which has the signature of the offended party in blank, no? There's only a signature, there's nothing else written above that signature. Now, the offended party the offended party, the victim, no, who made that blank signature, no, he delivers it to the offender. Take note, he has to deliver it. This estafa will not be applicable if the offended party stole that blank paper, no, with the signature. The offended party must have delivered it to the offender. And now that a certain document is written above that signature of the offended party by the offender without the authority of the offended party, no? Okay? The offender writes something there that the victim did not authorize, okay? And finally, whatever is written there, the document as written, no, by the offender, it creates a liability or causes damage to the offended party or any third person. Okay? So that's taking undue advantage of a signature in blank. Okay? Now we also have estafa by false pretenses or fraudulent acts. This is the second general kind, no? Earlier it's unfaithfulness or abuse of confidence. Now we have false pretenses or fraudulent acts or fraudulent means, okay? And then we talk about estafa by means of deceit, okay? There must be a false pretense, a fraudulent act, or fraudulent means, and these must be made or executed prior to, before, no, or simultaneous with, at the same time as the fraud which is committed. Okay? The offended party or the victim must have relied on that false pretense, the fraudulent act or fraudulent means, which caused him to, or induced him, no, which caused him to part with his money or property because of that false pretense or fraudulent act or means. And finally, of course, remember, the offended party or a third person must have suffered damage. Okay? If there is no deceit in that case, no, then there is no estafa, especially if the offended party was aware of the nature of the pretense, no? The offended party knew that it was false, no? So the element of deceit, consisting of the false statement or fraudulent representation, must be made prior to or at least simultaneously with the delivery of the thing, or the money or the property. Okay? It must be the very cause or the only motive which induces or causes the victim to deliver the money or property. Kumbaga, niloko ka. Okay? Niloko ka kaya mo binigay yun. Okay? To make it very simple. Ha? Now, under the first paragraph, under paragraph 2 of Article 315 of the Revised Penal Code, no? It gives us several ways of causing estafa, of committing estafa. No, first we have estafa by using a fictitious name. So for instance, a person finds a pawn shop ticket, no, which is in the name of another person, like let's say Juan de la Cruz. He goes to the pawn shop and redeems the jewelry by using or pretending to be Juan de la Cruz. He uses the name of Juan de la Cruz to redeem the jewelry. Okay? So in that case, he used a fictitious name. That's estafa. Second, no? We can also have estafa by falsely pretending to possess power. Okay? Such as when a person uses a paper without value, no? Like let's say he just invents a paper that has no value at all. You cannot convert it to money or anything else, no? He uses that paper to convince an ignorant indigenous person, no, who knows nothing about city life. He uses that paper to induce that person to sell his carabao. Okay? Or another example would be pretending to be a magician to locate hidden treasure. That's estafa by falsely pretending to possess power. Another one is estafa by falsely pretending to possess influence. So when a person pretends that he can influence a decision of public officials in the city hall or to perform a certain duty, then that may be estafa, okay? Because he pretends to have power to influence the public officials. Okay, fourth, estafa by falsely pretending to possess qualifications, such as when a person pretends to be a lawyer or pretends to be a doctor. And by pretending to be a lawyer or a doctor, he causes the other party to believe that, and the other party gives money or property. Okay? And in that case, that's estafa. Next, We also have estafa by falsely pretending to possess property. Okay? Such as when a person orders building materials to build a house, and he says, I have enough money to pay for that in cash. But the truth is, he doesn't have money. That's estafa. Or if he has 10 sacks of rice, he says that he has 10 sacks of rice, and the victim pays him 15,000 pesos. But it turns out he never had rice in the first place to sell, no? So that's estafa by falsely pretending to possess property. Next, we also have estafa by falsely pretending to have credit. Okay, such as when the offenders stated that we have credit in this store, no? This store owes us something, and you can pay us with some of the goods na lang, no? They tell it to the, let's say, the person on duty in that day, and that person on duty believes them, okay, because they seem credible. So those employees were induced to give goods, and they ran away, and the offenders ran away. That's estafa by falsely pretending to have credit. Another kind of estafa would be by falsely pretending to possess agency. Okay, in other words, let's say a person pretends to be a seller of a condominium, no? And he gets the money of the buyer by saying that he can sell him a unit, no? So in that case, to be safe, ask always for the written SPA or special power of attorney. I have a video on that. Just search for it in my channel. Okay? Another kind of estafa would be by falsely pretending to possess business. Okay? Like a person would pretend to be in the business of appraising jewelry. This is worth 10,000, like that. No, he pretends. Okay? Falsely pretends, and then he gets the jewelry to supposedly appraise it, and then he runs away. That's also estafa. And finally, also under the same paragraph, there's estafa by means of other similar deceits. In other words, by analogy, no, similar acts can also be punished here, such as where a person represents to the Register of Deeds in the City Hall that a contract was validly executed, so the Register of Deeds should register it or record it. Okay? So in that case, if it turns out to be false, then that may be estafa as well. Now, the pretense must actually be false, ha? You do not pretend and then as it turns out it's real. No. To be punishable, the pretense must actually be false in order for us to infer criminal intent. Okay, so the offended party must also be deprived of his property by any of those false pretenses. Now let's go to estafa by altering the quality, the fineness, or the weight of anything pertaining to his art or business. Such as, let's say, a jeweler, no? Who recasts or reforges a ring that was, let's say, 24 carats, and then he makes it of a lower quality, no? Like, basta lower quality. Or he replaces the diamond with glass, no? That is punishable by estafa. Another kind of estafa would be by pretending to have bribed a government employee. Okay, the offender in this case, he asks money from another person, not the government employee, from another person. Hey, give me money because I will bribe this government official. Okay, he asks money from the offended party for the alleged purpose of bribing a government employee, when in truth and in fact, the offender intends to convert the money to his own personal use. Okay, kumbaga he gets the money from that person, and instead of bribing the government official, he just runs away with the money. That's estafa. Okay? But if the offender receives the money, then he goes and actually bribes the public official or the government employee, then the crime may be corruption of public officer. Okay? And the crime of the public officer himself will be a different crime, probably under the Anti-Graft and Corrupt Practices Act, no? Among others. Okay? So, those were the crimes of estafa by false pretenses. Okay? We now go to estafa by fraudulent acts, which are characterized or founded on deceit. Okay? Just remember there is deceit in this case. In false pretenses, the deceit consists of the use of deceitful words, panlolokong salita. Okay, but in deceitful acts, of course, in fraudulent acts, they consist of deceitful acts. Okay, and these acts must be performed prior to or at least simultaneously with obtaining the property of the offended party or the victim. Okay. So first, we have estafa by post-dating a check or issuing a check in payment of an obligation. So of course, in this case, the offender must have post-dated a check or he issues a check in payment of an obligation. And such post-dating or issuing of the check was done when the offender had no funds in the bank or his funds which are in the bank are not sufficient to cover the amount of the check. And of course, the offended party or the victim must have suffered damage. Now, the check, it must be genuine, because if the offender signs a false name, no, not really him, no, then that's not estafa by post-dating a check. Instead, it's estafa by false pretenses using a fictitious name. Now, the check must be post-dated or issued to create the obligation. It should not be in payment of a pre-existing obligation. In other words, it has to be the reason why the offended party or the victim entered into the agreement. Okay? Because if the agreement exists before the issuance of the check, that's not estafa. Maybe it will just be a violation of BP 22 or the bouncing checks law. The deceit must be the efficient cause of the defraudation, which should be prior to or simultaneous with the act of fraud in order to constitute estafa. Okay? In other words, no, the offender, the accused, must be able to obtain the money or property of the victim, okay, because of that check, because he issued that check. Okay, akin na yung pera mo dahil sa check na to. Okay? And in other words, the offended party or the victim would not have given the money or property to the accused, no? Had it not been for that post-dated check. Okay? So, there is no estafa if the checks were merely issued for security or to secure the performance of an obligation. But if it bounces, it may be a violation of BP 22 or the bouncing checks law. Now, the mere fact that the offender had insufficient or no funds in the bank to cover the check at the time he post-dated or issued the check is enough to make him liable for estafa. The failure of the offender or the accused to deposit the amount necessary to cover the check within 3 days from receipt of notice of dishonor, meaning notice, he has to be given notice by the bank or the payee that the check was dishonored for lack of or insufficiency of funds, yung DAIF, no? Okay, drawn against insufficient funds. Okay, that one is that his failure to deposit the amount within 3 days is prima facie evidence of deceit, which constitutes estafa. Okay, so if the offender, the accused, is able to deposit the amount within 3 days, then he will not be liable for estafa. Okay, take note of that. No, now finally, just remember, no, estafa by post-dating a check is different from a violation of BP 22, the bouncing checks law. I have a whole different video on BP 22. Please just watch that. But I just want to say or reiterate that estafa is different from BP 22 because estafa requires the elements of deceit and damage, which are not needed in BP 22. Okay? An offender may commit a violation of BP 22 for the mere act of issuing a check which bounces. You do not look anymore into the intent, and you do not look anymore into the damage, which are required in estafa. And since the elements of estafa are different from the elements of BP 22, an offender may be charged with both crimes. Okay? He may be liable for both estafa and BP 22. Okay, now let's go on to the next fraudulent act, no? The next one would be committed in 3 ways. First, estafa can be committed by obtaining food, refreshment, or accommodation, okay, at a hotel, an inn, a restaurant, boarding house, lodging house, apartment house, no? Or similar establishments, no? Without paying for that food, refreshment, or accommodation. Okay? and there has to be intent to defraud the proprietor or the manager of that establishment. Okay? That is estafa, no? If you do not pay for your accommodation at the hotel or the food, okay? Another way of committing estafa under paragraph E of Article 315 is by obtaining credit at any of those establishments which I just mentioned, no? A restaurant, hotel, etc. Okay? He obtains credit by using any false pretense. Like, hey, I am Mr. Garito, ganyan, which is not his real name, etc. No? And the third way of committing a violation under paragraph E is by abandoning or surreptitiously removing any part of his baggage, no? Yung dala niyang mga maleta, no? From any of said establishments after having obtained credit, food, refreshment, or accommodation without having paid for it. Okay? Now finally, Article 315 on estafa punishes fraud, no? Through any of the following fraudulent means. First, we have estafa by inducing another to sign any document. Okay? In other words, the offender induces, no? He makes the other party agree or consent to sign a document, and that deceit must be employed to make him sign the document. Deceit, ha? D-E-C-E-I-T, okay? Now, the offended party, the victim, must have personally signed the document, and of course, he must be damaged, he must suffer damage or prejudice by such document. Now, it will not apply, no? There is no estafa if from the start, the offended party was already willing to sign the document. The offender or the accused must have induced the offended party. Now, take note, in estafa by deceit, that's common, no? The panloloko is the reason why the other party enters into the agreement or the obligation. Okay? So the offender must have induced the offended party to sign the document. Okay? And there is deceit as to the character or the contents of the document, like when it is different from those explained to him by the offender. In other words, the offender makes statements tending to mislead the offended party as to the character or the contents of the document. Okay? Now we also have estafa by resorting to some fraudulent practice to ensure success in a gambling game. Like pre-arranging signals, no? In a card game, no? When I do this, I have this alas, okay? Or an ace, no? Or fixing boxing matches, fixing basketball matches, no? Like that. That's estafa also. Another form of estafa would be by removing, concealing, destroying in whole or in part, court records, office files, documents, or other papers. Okay, so there must be intent to defraud another. If the documents, no, were destroyed, so that let's say the accused in that case would not be found guilty, it's not estafa, but it may be malicious mischief. Okay, so those are the offenses under estafa under Article 315 of the Revised Penal Code. Okay? And depending on the amount involved, the penalty for estafa can range from arresto mayor in its medium period, which is 2 months and 1 day, up to 6 months, up to the maximum provided by the law, which is capped at 20 years. It must not exceed 20 years. Okay? Now, if the offense which the accused or the offender commits does not fall under any of those many offenses which I just discussed, then the law also provides for other crimes, which I will now be discussing. Okay? First, now we have other forms of swindling. And the law lists several forms in this crime of other forms of swindling. Okay? First, we have conveying or transferring, selling, encumbering, mortgaging any real property while pretending to be the owner. Okay? So in other words, there is a thing, it must be real property like land or a building. And the offender or the accused, he is not the owner, but he pretends to be the owner. And that's the deceit, no? He pretends to be the owner. Then he executes an act of ownership over that property. Like he pretends to sell, he sells it, or he leases it, or he encumbers it, like mortgage, no? And that act of his, of selling, leasing, encumbering, it causes damage to the owner or a stranger. Okay? Another form of swindling is disposing of real property as free from encumbrance, even though the encumbrance is not recorded. Okay, in other words, the offender disposes of a thing which is real property. No, he sells it, no, or he can transfer it, and he knows that it was encumbered, meaning he knows that there is an annotation of a lease or a mortgage, or that some other person has a right over that thing, no, whether it is recorded or not. And there must be an express representation. The offender must say, no, he must expressly state or even write it, no, that the real property is free from encumbrance. He says, no, walang problema yan, malinis na titulo yan. Okay? And finally, the act of disposing that real property causes damage. Okay? Always remember damage, no? The offended party must have been deceived. Okay? Like in the case of a mortgage, no? He would not have granted the loan had he known the property had been previously mortgaged already. Okay? So there is deceit involved in that case. Okay? Now, another form of swindling would be wrongful taking by the owner of personal property from its lawful possessor. No, if you own something but you gave it to someone because you wanted to deposit it for safekeeping, or you wanted to pawn it, then they are the lawful possessor and you should not get it. If you get it, it's unlawful taking. But is that theft? No, it's not theft. Okay? In this case, the offender owns the personal property. There's no doubt. Okay? But it is in the lawful possession of another. The pawn shop, of course, has the lawful possession of the thing which you pawned. It's security that you will pay them the amount they gave you, no? And now, if the offender wrongfully takes it from the lawful possessor and damage is caused to that lawful possessor, then there is other forms of swindling. Okay, it's no longer estafa under 315, but it's another form of swindling which is also punishable. Okay, for example, no, the offender pawned a watch. He sinangla niya sa pawn shop, no, and he pretended to have money to pay. Okay, so when the pawn shop put it out of the caged window, no, he snatched it and he ran away. Can he be guilty of theft? No, that's not theft, because a person cannot be guilty of stealing his own property. Okay, the only time that will become theft is if he steals it and then he asks the pawn shop to pay for it. Hey, it was stolen, so pay me. That's theft now. Okay? But if he does not do that, then it will be estafa it will be other forms of swindling under this article. Another form of swindling would be executing any fictitious contract to the prejudice of another, no? To the damage of another. Such as when a person simulates a transfer to another to defraud his creditors. Let's say I have plenty creditors to whom I owe money, but I don't want to pay them. So my house, which they could have attached or used to satisfy my debt, I sell it to another so that I won't have to pay them. That's estafa. Okay, not estafa. Sorry. Again, it's other forms of swindling. Now, another form of swindling is accepting compensation or payment for services which were not rendered or for labor which is not performed, no? So, in this case, there must be fraud, such as when a person falsely states, hey, pay me because I did this job for you. Okay, there must be fraud. Because if it is not fraud, no, it's merely payment by mistake or solutio indebiti, then that's not punishable as a crime, and the remedy is simply a civil case to claim what was paid by mistake. Okay? Now, the final form of other forms of swindling would be selling, mortgaging, encumbering real property or properties which were used by the offender to guarantee the fulfillment of his obligation as a surety. Okay? So in this case, the offender or the accused is a surety in a bond given in a criminal or civil action, no? There's a case. And he guarantees the fulfillment of such obligation with his real property or properties. Okay? Then while that obligation is subsisting, he suddenly sells, mortgages, or in any other manner encumbers that real property without the express authority of the court, or made before the cancellation of his bond, or before being relieved from the obligation. In that case, that is one of the other forms of swindling, and he can be held liable. Remember, in all these cases, there should have been actual damage to the offended party or even to a stranger. Okay? And in other forms of swindling, the penalty is lower than that of estafa. Okay? Now, let's go to another offense. No, we have swindling a minor, which also has a lower penalty. So in this case, the offender takes advantage of the inexperience or the emotions or feelings of a minor, and he causes that minor to assume an obligation, to give a release, or to execute some transfer of any property right. Okay? And the consideration is some loan of money, credit, or other personal property. And also, take note again, there must be damage or prejudice to the minor. Okay? So, for instance, the offender causes a minor who ran away from home to sign a receipt for 500 pesos when the minor only received 400 pesos. Okay? And in this case, actual proof of deceit is not necessary because it is sufficient that the offender takes advantage of the inexperience, or emotions of the minor. And finally, we have the catch-all provision, which also has a lower penalty. It's known as other deceits. Okay? So, the first is defrauding or damaging another by any other deceit, which is not mentioned in the preceding articles which I have just discussed. Okay? And so, any other talaga, as long as it's deceit. And the second would be by interpreting dreams, by making forecasts, by telling fortunes, or by taking advantage of the credulity of the public in any other similar manner, okay, which must be done for profit or gain. Okay, so this article on other deceits, it covers any other kind of conceivable deceit that you can imagine, as long as damage is caused to the offended party. Okay, one example would be obtaining a loan on the promise that real property would be given as security, as mortgage, for security, but that real property wasn't actually given, So, because let's say the borrower sold it to someone else, that falls under other deceits. Okay? Or let's say a bus conductor, a ticket, the one who sells tickets, A bus conductor who collected 12 pesos, but the real value of the ticket was only 10 pesos, then that is that falls under other deceits. Or final example would be using a public vehicle like Grab or a jeepney, without money to pay for the fare. That falls under other deceits. Okay? So that's it for estafa and other related criminal offenses. I hope you may have picked up a thing or two, and I hope you wait to watch my other videos. Okay? So see you soon, guys. Bye.